pleased to bring you a panel discussion of legal topics with two attorneys. Both have offices in Ormond Beach, Florida. Courtney Kilbourne Hayes is the owner of Coastline Legal. Welcome, Courtney.
Thank you, David.
Also joining us is Wendy Mara, owner of Mara Law. Welcome, Wendy.
Thank you, David.
Good to have both of you. And we're going to be talking about some legal topics. Of course, if you're listening or watching the program around the country, laws may vary in your states. So let's start with probate. I know this is something we could talk about for about 3 hours, okay? So what is probate and is it required? You want to get us started, Wendy?
Sure. In the simplest of terms, probate is transferring assets from the person who has died, the decedent, to whomever is entitled to those assets.
Okay, pretty simple. We're all done. So in that process, this is overseen by the court in the person's local area, and that process is a matter of transferring legal title of their assets to their intended beneficiaries.
Yes.
Okay. And so during that process, what happens from the moment the person passes? Kind of give us a quick run through of like, okay, this happens, and then this happens.
Okay, David. And much of this depends on whether there is a will or there is not a will.
Okay.
So if there is a will, in Florida, we deposit that will with the clerk of court. In some other states, wills are deposited while somebody is still living. That's not allowed in Florida.
Okay.
And so then once that process has begun, there are petitions that are filed with the court, and the first thing that needs to be done is to get a personal representative appointed. And that personal representative is the person who has the legal ability to gather the assets, determine who creditors are, determine who beneficiaries are, and then pay creditors, then pay beneficiaries, and close out the estate. And again, that's in the simplest of terms.
And that person is identified in the will?
Oftentimes, yes.
Okay.
Assuming there's a will.
Right.
And then sometimes you have different situations where the person who is appointed is no longer living, no longer has capacity. Then we're looking at successors. Sometimes even the successors are not available. So many times in that situation, the beneficiaries will decide on somebody who can serve. And so it really depends on what's going on there. But ideally, it's the first person who's been chosen. Okay.
And from your perspective, Courtney, you do a lot of estate planning and getting people to get the right documents in place, to name the right people in these documents who are going to serve. What have you seen in terms of this probate process, that the importance of having all of those things put together in a way that's going to make it efficient and make it work well?
And that's a fantastic question. And I would say most people would say they hate probate. They don't like the process, they're grieving a loved one, a family member, or a friend, and they just don't want to do it. So, and I deal with the front end, so I do all the planning, and we try to get as many assets as possible out of probate. So there's certain tips and tricks that we can do that avoids probate, but yes, most people say they don't want to deal with the process. But if it's unavoidable and you do have assets you've acquired over time, you do want to make sure that you set them up properly and your intentions are known, who you want the beneficiaries to be, and backup beneficiaries. I always say backups.
Just in case that person predeceases the...
Exactly.
Yeah.
And then that's also why we go through a review period, whether it's every year or a big life change that happens. You want to go back to your law firm, your attorney, or whoever will help you with the planning to make sure if any other life changes has happened that it's updated so that when you go through probate process, it is exactly what your intentions are.
So there's some advantages with avoiding probate, so to speak, that often people hear about. It's, probate can take a lot of time. It can cost a lot of money. It can, be a variety of things. But there are some, I would imagine, some advantages of probate, especially if you're dealing with creditors or other things. Can you speak to that, Wendy?
Yes, David. With a probate, you are able to, in essence, knock out creditors. So if you have known creditors, and this is again in Florida, if you have a known creditor, and I tell people right away, do not pay creditors of the decedent. Don't do that. If you're doing a probate, wait for the probate process. We send a notice to creditors to known creditors, and those known creditors have 30 days to file a claim. If they fail to file a claim, they're out of luck. They don't collect. And for unknown creditors, in a formal probate, you are required to publish a notice to creditors in a local newspaper, and those creditors have 90 days to file a claim. And there are many situations where claims are never filed. And some of them, I've had some of them $70,000,
Wow.
$100,000, where if somebody had just written a check out to that individual or that company, the beneficiaries would receive less.
Okay. And one of the ways that people will often look at avoiding probate is with a trust. And you talked about that, Courtney. So with a trust, they can avoid having to go through probate, which of course means you're using your will, right? I mean, the will is for the probate process. Talk a minute about how that trust allows them to kind of bypass that, maybe some of your tricks and tips that go with that.
Yes, so a trust is an excellent tool to avoid probate. And the key part about that is it will automatically go to the beneficiary upon passing. So you don't have to go through the actual court process and notifying creditors or anybody else. It just, you automatically have your interest in that, whether it's real property, if real property was put into the trust,
Right.
or if, say, it was a couple other assets, tangible personal property. Otherwise, a lot of times we also have insurance policies, and they go straight
By
with the
beneficiary
trust.
designation.
Yes,
Mhm.
exactly.
And you can also do pay on death,
Yes.
transfer on death. These are also ways to do that.
Oh, yes, absolutely. And I give those tips and tricks to the clients when they come in, and that's part of the valuation of the estate, is to check out, well, your bank account can immediately go to your beneficiary if you do the pay on death. You have to do it with each account and each bank,
Right.
but they don't have to go through the probate process to go get that $4,000 or $40,000, whichever it is.
Okay. And now with the trust, Wendy, there's still some court involvement, correct?
Yes, we file a notice of trust. And so with that, creditors do have an opportunity to be made aware that there are some assets there. And most trusts have language that any creditors need to be paid. So if the goal of your estate planning is to avoid potential creditors, then having those pay on death accounts, they never get a bite at the apple.
Right.
It's upon the death, those are automatically become the beneficiary's property, even if the process has not been gone through yet. Same thing with homestead. Upon death, automatically the beneficiaries become the owners of that homestead. You just have to go through the legal process of retitling it. So if you're wanting to avoid creditors altogether, doing those direct beneficiaries is really the way to go about it.
Well, with all of that, and I think the viewers need to see this picture, is that with all of that, it really, really depends on their individual situation how you're going to put this together. Maybe we want a will to go through probate. Maybe we want a trust. Maybe we want to use some of the tips and tricks to go POD, TOD. Maybe we've got a lot of debt that we're trying to, not have to eat away at what the next generation is going to get. So all of that can create a multiple variety of different ways of putting this together.
Absolutely.
Yeah, so one last final question is about spouses. So when you're doing this transfer, how do spousal rights come into play when you're going through this process?
That's a really important question. Now, if both of the parties own the assets, it's really not an issue. The other spouse takes, and it just isn't an issue. But with people having subsequent marriages, it's not uncommon for somebody to decide to keep, each of the spouses to keep property in his or her own name. So then if that person failed to have a beneficiary on accounts, then it's going to have to go through probate. If both spouses were living in one of the spouses' homes and it was never retitled, then it has to go through probate. Our state does not want to leave a spouse impoverished, so there are protections there.
Okay.
So personal property, a vehicle, the homestead is sort of it's treated specially. The spouse either gets a life estate or can elect to take 50% of the value of the property, have it sold. But they have to file that election in Florida, have to file that election within 6 months of death. So if you don't know that, one of those things you don't know, then you've got a little bit of a problem there. So, and then also there's an allowance for spouses. The elective share, 30% of the value of the estate that they are entitled to if they haven't, if that has not been left to them. And also money available for helping support, they call it maintenance,
Right.
up to $18,000. It can be
Okay.
paid in a lump sum or monthly. So there are lots of protections for spouses, but the important thing is upon the death of your spouse, I mean, the last thing you're thinking about is going to see a lawyer, but you really do need to, because some of those have time frames that if you miss the boat, you're out of luck.
Don't miss the boat. That's really the key. All right, good. Great insight, ladies. Very helpful. Thank you very much.
Thank you, David.
At Holland Financial, we know a strong retirement plan is unique to you. Let's find the right plan together. Holland Financial. Plan Stronger.